to log on. It's a good place to call a friend and tell them that the conversation with the RGPF is on for this morning, Wednesday, the 19th day of March 2025. And of course, I'm going to be your host for this morning's program, Constable Callis, for the next hour thereabout. And I'm going to have all of your company and all of your attention this morning because we have two gentlemen in studios with us this morning. I'm not going to mention the name as yet. They are going to introduce themselves. But however, when we talk about prosecution, we often talk and worry about a lot about the summons in particular, because sometimes we are of the opinion and believe that once you hear prosecutions coming at you, you're looking at money. But however, that may not be the case this morning. We're actually talking about prosecution rules and function and just some of the necessary services that they are providing to you, the general public, on a daily basis. So, morning once again, and thank you for joining us here on the program, the conversation with the RGPF. And to those out there in the diaspora, wonderful Wednesday morning to you. And it's good. It's quite hot and sunny on the outside. And of course, to you, the motorists out there, your advice, caution, and encourage to follow all the road regulations that are required for you to traverse along the nation's road and to be able to carry your passengers to and from the destination safely. And those of you, remember there are still construction happening on the roads. And of course, we want you to drive with due care and attention. So be on your best so that you can get to your location and destination as quickly as possible. So welcome again to the program, and I'm going to take the opportunity now to say good morning to you, gentlemen, and how are you doing?
We are fine. Good morning. Good morning. Can't complain.
So let's just be able to have a brief introduction, and we have Constable Williams with us, and we have Corporal Charles with us this morning on the program. Just share a little light of your experience thus far within the RGPF and having to work within the prosecution department.
Good morning to all the viewers who are locked in, those via the World Wide Web. Pleasant good morning. I'm Corporal Charles, presently attached to the Prosecution Department as the officer in charge of process. Good morning to the viewers and the listeners. My name is Kellon Williams, Police Constable 428, attached to the Prosecution Department. So far, my journey with the RGPF has been a good one. I can't complain. So I'm really looking forward to this discussion here today.
Well, and that's quite important to know that you all have been enjoying your stint within the RGPF thus far and having to be able to ensure that the public get the necessary service that is required from you persons and of course the department that you represent and the RGPF by extension. So this morning, let's talk a bit about prosecution. I know persons would always be interested in having to understand what prosecution is all about, the role and function. So let's dive into that aspect of it this morning. Let's be able to explain to the general public the roles and functions of what is prosecution department all about.
All right, I could start off. The Prosecution Department basically is a governing body within the RGPF that deals with prosecuting criminal and traffic cases or matters, upholding the law and ensuring that justice is served. The word prosecution basically means to hold a trial against a person who is accused of committing a crime to determine whether or not they are guilty or not. So the Prosecution Department is broken up into three different subheadings or categories. You have the administration, and that department deals with the paperwork, you could say, record keeping, receiving of case files, reviewing case files, preparing files for the prosecutor and so on to take to court. That would lead me to the second category, the prosecutorial. That's where you have the prosecutors. Their role is to take matters to the court, to present evidence, facts, to get witnesses ready for trial, to brief them, refresh their memory, and so on. And that will take you to the third category, which is the process unit. And that's where you have officers dealing with summons and warrants and getting persons to come to court and so on. That's just a brief outline.
All right, to add to what Officer Williams would have stated, the prosecution department is really a unit within the RGPF, with its headquarters being located at St. George's. And it also comprises of sub-units in the various parishes. For instance, in the parish of St. John's, you have a sub-unit there, St. Mark's, St. Patrick's, St. Andrews, and St. David's. And they all work hand in hand to ensure that justice is served on the various individuals. The prosecution department plays a critical role in criminal justice system. It is responsible for representing the state in criminal cases and ensuring that justice is served. Prosecutors work to uphold the rule of law, protecting the public and ensuring a fair trial.
And that is quite important. So in short, the prosecution should not be what we say prejudicial, or in other words biased in the whole trial of any case. Yeah, it is a whole point of having to bring forward the evidence before the court so that the accused or the alleged person can either be found guilty or innocent of the case that is brought before them.
And to also add to what Officer Williams would have stated earlier, the prosecutors have responsibilities in the department. And I will make mention of some of the responsibilities. They are responsible for reviewing case file, assessing evidence to determine if a case should be proceed to court. They are also responsible for charging decision, deciding whether to file criminal charge and what charge to pursue, presenting cases in court, advocating for the state in trial and hearing, protecting victims and witnesses in proceeding, so they ensure the safety of witnesses, advising law enforcement, providing legal guidance to investigation and evidence collection. They ensure that evidence is legally obtained and admissible in court. Seek justice rather than merely seeking conviction.
Now you mentioned a key thing here, and I think it's quite important for us to just zero in on it a bit. Most persons do have concerns in regards of the safety in terms of being a witness. You would have offenses or criminal activities occurring, and someone may have seen what had happened or had knowledge of an incident, but they are somewhat timid or frightened to come in because they are not certain as to the level of safety or security that will be provided for them if they decide to come forward and to be able to say to the prosecution or so, listen, I'm a key witness in a matter that you are investigating, but I want to be able to be safe. That I want to know that if I give you that information, I would be safe. How best, or what advice can you say to someone who might just be listening this morning as relates to the safety and security as a witness?
I think in cases of this nature, confidentiality is of paramount importance. And if persons happen to be a witness in these matters, for instance, let's say a domestic violence matter, the prosecution could make certain requests to the court whereby the accused or the defendant could be relocated to a different area, so to avoid any confrontation with the witnesses.
I think that has also plays up a lot with some of the sexual matters that are brought forward to the court. You know, you might just have the victim and the perpetrator living within the same proximity, and a result of not having to interfere or contaminate or to be able to say to that victim certain languages, you know, to deter or to have them change their mind. The prosecution department or the prosecutor himself should have that leverage of legal rights to be able to safeguard that victim.
I think what happens sometimes in most cases, provisions are also been made for the victims, whereby they could be relocated, whatever shelter is available for them.
Okay, wonderful. Let's look at some of the challenges. I know that every aspect of job or work environment there are challenges, but what are some of the challenges that are faced by the prosecution department?
Well, I think I could start off with that. The unwillingness of the public to cooperate with the police. Sometimes when we go to look for persons, they don't want to cooperate, they don't want to give us any information as to where this person lives or where we can find them or those sort of stuff. So we are enforcers of the law, and we try our best to administer justice to ensure that justice is served and impartial. But we need the cooperation of the public. So the unwillingness of them to work hand in hand with us sometimes, you know, poses a problem to us.
I think most of the time the public have a perception that if they pass on information to the police will use that information and give it to accused person, letting them know, all right, that information was given to me by Jack or Jane. But this is not so. It is just a myth. You understand? If we out there in the community and someone wants to give us any information, it is private and confidential. So I don't know why persons have that perception that if any information is given, it will be used against them. What I will say, the community and the police need to work hand in hand. If our offense happens to be committed in your community and you decide to remain silent, the police cannot do it alone. So we need that partnership whereby the public should come on board and work hand in hand together with the police. Because if you're in a community and crime is being committed and you sit and say nothing, then you contribute to the increase in crime. When you could play a key role by assisting the police and giving the necessary information, you would call into the station, you have to give your name. Whatever information you have available, you could just call, you pass it on to the officer, they will take the information and they'll work on it.
Very well.
Another problem we have is persons not showing interest in their matters. You would make a report to the police, you would request court action, the matter will be sent to court, and as the complainant that made the report, he or she fails to attend to their matter. Even after being served, they would not show up in court, and ultimately that matter gets struck off. And as I say, you know, it take up the court's time. So showing interest in your matter, even for the defendant to come and give your side of the story, to show your cause, you know, it goes a long way. So when we have to always re-summon and adjourn, it takes up time from the court and also the officer. So show interest in your matters for both complainants and defendants.
I think we are living in a culture in Grenada, right? We have issues surrounding our society and between individuals, and at the spur of the moment you get angry, and right there and then you want to take that person to court. You know, so you go, you go to the police, you make that complaint. Yes, you want good action because you're all furious, you're angry, you want that person to, or you say you want justice. So the court is the best place. But 2 days, 3 days down the road, I'm not bothering about this matter again, and there's this whole, could this be one of the major factors that are really challenging the prosecution system or department as it relates to individuals not having interest in the matter again after they would have reported and requesting good action?
I think right now a burden is placed on the system, as you say. There are trivial matters which could be dealt with. For instance, threatening language, insulting language, obscene language. Two persons in a committee might have a confrontation. You understand? Parties get hot, they exchange words. One run to the station, who want to take the person to court. As you clearly stated, 2 days after, they change their mind. And with these trivial cases, it tends to create problem into the system. Problem in the sense that when the court should be looking to deal with serious or more serious matters, they have to attend to these trivial cases. Not only, you place a strain on the resources. So the prosecutor, the process servers now will have to find themselves out there, wherever you live, to locate you and give you the summons, only to realize that you're no longer interested in the matter.
No further action.
When you could have gone in at a later date and say, hey, we make up that, let us forget that. So that in itself, as I stated earlier, places a burden on the system. When resources is placed on those trivial offenses, instead of it is being placed or focused on the more serious matters, that of indictable matters.
And again, we just spoke as relates to persons not having interest, and you as prosecutors from the prosecution department have that responsibility to ensure that complainants and defendants, witnesses comes to court whenever there is a hearing. But is there a challenge as it relates to relocation of complainants or maybe victims or maybe defendants? Does the prosecution have any challenges as it relates to that?
Yes, we do have challenges at times. Challenges in the sense that persons, they say they might be living in a particular village. When they would have come to the station and passed me the report, after that, they would have migrated, would be somewhere within the state of Grenada. So or the process servers now have that problem in locating this individual. Sometimes you don't have no knowledge as to where they might migrate to. So it places a burden on the system in order to locate these individuals. It also creates a backlog in the system. So these matters keep reoccurring. In doing that, they meet recent matters. So let's say, for instance, you had about 50 matters in the system, and the accused or the witnesses are unable to be located. And then you have every week you have new matters coming in. So then there's accumulation of matters.
Of course, that in itself puts a strain on the whole system and the process of solving of individuals of matters that are, I don't want to say more important, but everyone should be equal. But when you have such a challenge and you have to use up your resources to find these persons with all of the interests to ensure that fairness is across the board, it takes a lot of time from the system.
Also to add, well, if you have a matter at the court and you no longer want to pursue that matter, I think it's best that you contact the court or come in and say that you no longer request further action in that matter, or even speak to your lawyer. If you don't want to come in, your lawyer can relay that message to the prosecution department, and that should straighten things out instead of prolonging.
I think most of the time persons tend to take the system for granted. Because, for instance, summons might be issued to parties and they would have settled it. You understand? Between them, they would have settled that matter. But you settling that matter out there, the court has no knowledge
Of the matter being settled.
as to that matter being settled. So most of the time, persons will be served with a summons to appear court and they will refuse to show up. Taking into consideration, okay, we sort out that and that is there. But the system don't operate like that. If you are served with a summons, you need to attend court. Because a summons, right, is a command from a competent authority requesting your appearance at the appointed place and time to answer to a complaint. So that, and the competent person in that sense is the magistrate. And when you refuse to show up, it seems as a disrespect.
To the court.
You're not disrespecting the process server, but you're disrespecting the magistrate. So then the magistrate in turn now will have to prepare a bench warrant for that individual. So then they're talking about the consumption of resources.
And it's not just your resource from a prosecution department, but you're looking at time constraint from the complainant aspect itself, because you might be working as a complainant, and here it is, I have to serve you that warrant, you know, and it means serving you that bench warrant doesn't mean you're staying home. You know, it means that you have to accompany the process server.
You'll be
You understand?
in our custody.
In custody as well.
Yeah.
But to add what you stated, so many persons involved in these matters might be employed. So let's say, for instance, the victim happens to attend court, but the accused decides, all right, I'm not going. So that person now takes a day off to attend court. And then you being complacent, you fail to attend court. So that person will lose a day with payment. Who is compensating them? Most of the time that question will be asking court. You and I take a day off to come here. Who is compensating me? Which I find is unfair to the individual. And these are the challenges we have to work with on a daily basis. So people not take into consideration that when you become complacent, you're inconveniencing our individual.
Also to add, being complacent has its consequences, because if you're served with a summons and you fail to come to court, as the corporal said, a number of things could happen. You can be served with a bench warrant to assist you to come into court, as well as the hearing can be done ex parte, meaning that it will be done in your absence, or as they say, behind your back, and then you'll be fined and you will not know about it, and that's when a warrant is going to come out for you. If you fail to come to court and a bench warrant comes out for you, it will inconvenience you as the civilian. If we see you on a Friday, there is no court Saturday and Sunday, so we would have to bring you into custody, and you might have to stay in until Monday when you have court. So that's how fight can go. So that's why it's best to just cooperate with the police. When you get a summons, show interest, come to court, so it doesn't have to reach to the state of a bench warrant coming and meet you, and we have to bring you to court.
And persons who fail what they fail to realize, right, a bench warrant could be executed at any time. As long as the officer has a bench warrant in his possession, it could be executed a month before. And if that's the case, that person is brought to court, the magistrate could remand that individual.
Have that power to remand that individual until the hearing of that matter.
So just because of your negligence, there are serious consequences.
And I do believe that the magistrates sometimes are quite lenient, because you have a matter that you first hearing, second hearing, it doesn't show up. You know, you may, on the third one you might get a summons. You have an affidavit that is shown to the magistrate that yes, that you were served, but yet for all you still fail to show up to court on the next hearing, you know, and here it is, they might say, okay, here's what it is. Either that individual doesn't have no interest in the matter, or he's just blatantly disrespectful to the authority. And here, I am not going to issue a warrant, a bench warrant, to have that individual brought before the court. And sometimes, I mean, I've been in court and actually heard, you know, persons giving some lame excuses,
Definitely.
you know, as to why they couldn't come to court. Maybe I didn't have anybody to see after the children, or maybe I didn't have money to pay bus, or I get it someone's late and I couldn't come. And here it is that the magistrate now has to make that decision, you know, based on the nature of that offense or the crime that has committed, to maybe, as you rightly said, to remind you.
I think using of summons as an excuse, I don't think it makes any sense, all right? Because most of the time, the summons will be served way in advance. So you're talking about you have 48 hours prior to serving of that summons, all right? So when that summons is being served on you, you have sufficient time to prepare yourself to attend court. There are rare occasions where a summons will be issued to you, perhaps served to you a month before. So it's not a situation whereby you might say, okay, I received that summons since last month and I forgot. No. Or it could happen. But most of the time, you know, we take into consideration how we understand people are human beings, and we try to give them, hand it to them as close as possible, but within the armpits of the law. So it wouldn't be a day before. There are exceptional cases. For instance, you cannot locate an individual, made numerous attempts to locate him, and you didn't. And it just happens that the day before, you happen to see him, and you give it to him. So then he now have an option. He could go to court and he could let the court know, hey, Your Honor, I only received that summons the day before. And she will grant you adjournment, giving you time, because you may want to seek the assistance of a solicitor.
But how's the challenge, right? Let's use just that example that you gave, right? Let's say a day before, within that 24-hour period, but that individual is working, and with all of that working environment, some of our bosses, you know, find it very difficult to give that individual time to go to court, because as a boss, a manager, is seeing that I am losing time. I cannot have the production of that particular individual on that particular day because short notice I have to. So what advice? I mean, I believe that it is a challenge, you know, to the system as well. But what advice would you be able to give to managers or so forth when persons who are under their watch, you know, have those type of documents to attend court?
All right, seeing that the notice was short, as you say, a day before, I think it is understood. The individual could get in contact with the court and let them know, because it is not compulsory that a person attend court, because it's supposed to be 48 hours and not 24. So a situation like that, it becomes optional. Although some magistrate will tell you, all right, even though you receive it late, attend the court, let me know, and then I will make whatever decision. You understand? Mm-hmm. So I don't think the onus is on the
managers.
On the managers. You understand? It is not granting of that permission is not compulsory. Unlike if it's a situation whereby the person would have received it within ample time.
To make preparation.
You should not deny that person that opportunity.
And
although some of them tend to do it. Because I know in the case of juror summons, like person who has to perform juror duties at the High Court, if the employer denies that individual, the judge will definitely send for you, and you'll have to answer as to why you deny that person that opportunity to attend court as a juror.
Because you normally do hear persons complain of those situations, you know, and I think that's why it's earlier on, Constable Williams, you mentioned a person no longer even have interest in the matters, you know, because the time to get from the jobs to come to court is always a challenge, you know. So we understand where the situation is, you know, but persons should be able to have that open dialogue, open conversation with their managers, you know, informing them, hey, I have a matter in the court coming up so and so time, you know, next month at that date. So manager could put things in place, you know, to accommodate you to be able to attend the court.
And I think what poses a challenge sometimes, an individual might have a matter pending in court, and as someone would have given to that person before. But it is not a situation whereby whenever you have to attend a court hearing, a summons will be given to you. So most managers or employers will request a summons. But the person would have a summons before. So they wouldn't be receiving a second, a third, or fourth. So they might just go to the boss and say, hey, I got a matter next 2 days from now. So I'm requesting permission and don't expect a summons.
And another problem I realize that we have as well from the prosecution department is, let's say we go to execute a warrant on an individual. We find that the persons or the public would intervene and try to pull out the person that we're trying to apprehend, and that amounts to obstruction. And it's a trend that is going on, and I realize that we're following the outside world. Their culture is different to us here, and that's something that we need to buck up on. Because
that's one of the pointers I was about to ask you. All of the challenges that the prosecution department may have, but what of some of the offenses that can come out of all of these challenges? As you already said, the bench round or maybe the summons. Just giving someone a summons and it's like, officer, that is not my name, I ain't coming to court, or take that summons and just throw it on the ground. There must be some form of offenses that may come out from all of this.
So to add what Officer William would have said, yes, there are offenses arising from a situation like that. As clearly stated, obstruction. And obstruction could be in words and it could be in action. Mm-hmm. Words in the sense that, officer, leave the man alone, the man don't do nothing. Why don't go nowhere, you don't do nothing? That in itself is obstruction. The mere fact that you decide to pull that individual away from the officer, it's also deemed to be obstruction, and persons could be arrested and charged for it. Yeah. Most of the time, I think officers tend to be lenient on persons. So, seeing that leniency is exercised, persons take advantage and they abuse the system.
Yeah, once you are hindering the
actual duty,
right, the duty of an officer,
yes,
right,
yes,
the hindering the execution of duty of an officer, you are committing an offense, obstruction. So I think we need to refrain from doing.
And you see, and every day is something that you witness. And the way people say, oh, it's my right, it's my constitutional right. You understand? The Constitution tells you what you could do and what you cannot do. It talks about its freedom of speech.
Right.
But is how you use it. It does not tell you that you could go about disrespecting someone, making use of obscene language to someone. So I think most of the time now people get those things and they mix up as to what is freedom of speech and what is an offense.
And in the mere fact you have an officer that is on duty and is in the performing of his duty, and here it is, you are obstructing him from executing that duty, it will amount to you committing an offense. You know, so person ought to be mindful of that, because in most cases is that they're not helping the officer to execute his job. You know? They're making it more tedious, more of a challenge for him, because what I sometimes see do happen is that the individual who comes around, they tend to spark more fire.
Insight. Yeah.
And you know, as I say, they incite more things, you know, and from out of just maybe the obstruction, you may have other offenses accumulating.
Because you might look to resist the officer.
You might look to resist.
You might look to assault the officer. You might look to make use of obscene language.
You know, so all of this things. So all that is important is for individuals to comply, individuals to work along smartly, you know, with the officers, so that the duties can be performed.
And you see, we don't want the public to see us as the enemy. We are not the enemy. We want to work hand in hand. You understand? Imagine a country without any police officers. What would it be like? Chaos. I don't think persons take this situation into consideration. You understand? That the police needs them, and they also need the police.
Because
as some people will say, after God is the police.
And the mere fact, Corporal Charles, is that you are operating, or the prosecution department, when it comes to the process servers, they are operating under directives given by a proper person in light of the magistrate. Now, if at the time when you have your function to do, which is to execute maybe the summons or the warrants, whichever one, and you fail, then you have to answer to that authority, you know, that proper person. And that in itself can pose a problem. Disciplinary action can actually result.
And you see, these are things that persons don't understand. You understand? That you have to give account to somebody. So most of the time, there are decisions that you cannot make on your own. You're acting on instructions. And you cannot go contrary. And people need to understand. So because most of the time, if we have the power, there are sometimes certain leniency we might exercise.
Definitely. Now, let's move a little bit forward. It's now 10 here in the conversation with the RGPF, and we're speaking with two officers from the Prosecution Department, that's Corporal Charles and Constable Williams. However, let's look at a situation as relates to summons, because it's something that I often hear people speak of, and sometimes they don't show up to court because the summons that you serve on them does not carry the right name, you know, and they say, officer, this is not my name, this is not how my name is spelled. I may know of the situation, I may know, but that's not me. I am not accepting this summon, you know. What advice, recommendations should you give to persons when that situation arises?
Most of the time, when we confront situation like that, I let the persons know we are only the postmen. Whatever might be written on the summons, we have no knowledge of that. So the best advice that we will give to an individual, the day in question, attend court. While we are on that, I'll give you an example. Once someone was served an individual, the first name was correct, but the surname was wrong. Going through the body of the summons, I realized that the incident took place with he and his neighbor. So there and then, I asked him if he has knowledge as to any mishap between his neighbor. He told me yes. I said, okay, so you have knowledge as to the incident, so then you need to attend court. But he said, officer, it's my first name, but his surname is not mine. So I said, you need to come to court to rectify that. He refused. A bench warrant was issued in the same name. And we went and we executed that bench warrant on the individual and brought him to court. He raised the said issue in the court, and the magistrate said to him, he was given an instruction if you had any issue with the summons, the officers cannot remedy the situation. You have us to come to court. And there and then he understood. So it is not there is no reason for people to refuse a summons if it is not, they say the surname is wrong. Because someone could be issued to you with an alias.
Right.
So persons in the area know you as by a particular alias.
A false name.
They could use that. The summons, the court interested in you as the individual, not the name.
And the mere fact that you have knowledge as to the incident is what compounds the situation. You know, that is so significant for you to clarify, you know. And that's where the name now is more important, so that the proper documentation can be placed on filing. I remember earlier when you spoke as it relates to case file preparation for the court, right? To send the files, to scrutinize and to ensure that the file or the documents are ready, you know, for court setting. How much of a challenge is this for the department in terms of files brought in and, of course, let's say the evidence is not clear, you know, and so forth. How is this? Is this a challenge for the department?
Sometimes, yes, it is a challenge, but the prosecutors are the one that review the case files, and if he or she sees that evidence is lacking, he will give instruction to the investigators to go out again, get a statement, gather more evidence, and, you know, bring it back. So he's the one that is responsible for presenting evidence, the facts, to bring forth to the court. So to build a real case file and so on, the prosecutor's role is very important, as well as the investigators, as well as the person that even received the case file. So if anything is wrong with the case file at first, the person that is receiving it would most likely pick it up. But then there's so much case files that keep coming, there's so much offenses, it's sometimes hard to keep track, but we're all humans, we make mistakes at times, but the RGPF has capable persons, the prosecution department has capable persons that pick up on those things, and we try our best to remedy the situation and make do with what we have at the prosecution department.
I think what happens most of the time, an investigator might be investigating a matter, and there is insufficient evidence to prefer a charge against an individual. So what he will do, he will still go ahead, prepare that file, and pass it to the prosecution department, which does not make any sense. If the evidence is weak, why pass that file? But the prosecutor in turn now has that authority to determine whatever matter goes to court.
Okay. Let's look at the different types of services that are provided in light of the execution of different types of warrants from the court that the process server would normally do on a daily basis. And you spoke about the bench warrant earlier, but let's just look at the other type of warrants that might just be executed.
So we have the JDS warrants.
Yeah.
These are what we call the judgment debtor warrants. And these warrants are issued in situations whereby civil matters or civil matters or maintenance cases. So it's situation where persons owe individuals. So the court in turn, there will be a hearing and the man should make a decision on that warrant. And the bad thing about, or we deem that warrant to be very, what should I put it, dangerous. Dangerous in the sense that it is not a warrant that you could do time on. So the warrant there will be directives on the warrant that all right, that person should pay, let's say $5,000 or 2 months in prison. Even though you serve that time, on completion,
You still have to.
the person could reapply, and that warrant will be back in the system to be executed on you a second time.
Once the funds is not paid in full.
Definitely. Then you have the commitment warrants. And these warrants are issued for both criminal and traffic matters. So person go in court, whether it's a harm offense, the magistrate impose a fine on you. You are given a specific time to pay, let's say within a month. Failing to do that, a warrant will be issued for your arrest. Same thing goes with traffic offenses. Then you have what we call search warrant. You might hear a lot of people talking about search warrant. This warrant gives the police the authority to enter your premises and conduct searches, whether it be drugs, ammunition, predial produce. It gives you that authority to enter the premises. It also gives the executing officer certain directives. So for instance, if the police come at your home with a warrant and the police certain that you're in there, most of the time that warrant give you the authority to enter that premises by whatever means necessary.
So in other words, an individual should not refuse or deny an officer in that execution of that warrant.
And as the individual, you have the right for the officer to read that warrant to you and show it to you. So officer should not just be coming to your premises and say, hey, I have a warrant to search. It's your right to view it. But you wouldn't hand it to you. You hold it in a distance that you could view it and read it. Because we don't want to, we hand a warrant to somebody and they repeat. They damage it, they destroy it. It will be read to you, read and shown to you.
Wonderful.
Added to what Corporal said, you have the adjournment warrant. That warrant is if you're charged with a particular offense, you're brought to court. Your matter might start today. It may not finish. The magistrate might issue an adjournment warrant. Ask that you be remanded to His Majesty's prison until your next hearing. So that document is what is going to hold you at the prison until your next hearing. That's your adjournment warrant. Also, I wanted to touch on the bench warrant one more time.
All right, just hold on.
Okay,
With the adjournment warrant, as William stated, it gives the prison officers the authority to accept you. Without that warrant, they cannot accept you in the court, in the
prison.
At Her Majesty's prison. So the individual must be accompanied by that warrant. And we deem that to be adjournment warrant. Then we also has the delivery warrant.
Yeah.
If someone is in prison and we need to get that person to attend court on a specific date, then the court will issue what you call a delivery warrant. So that now warrant gives the prison the authority to release you.
Okay.
Without that warrant, the prison cannot release you. So when you look at it, everything is about paper.
Well documented and have to be executed at the right time so that the right service can be provided. Yeah. It's just 2 minutes on to the hour of 10 o'clock. We're winding down here quickly on the program this morning, the conversation with the RGPF. Are there any final comments from you, Officer Charles and Officer Williams, that you would like to make this morning as we conclude the program, the conversation with the RGPF?
Well, before we leave, the prosecution department basically wants the public to. We're trying to build confidence in the criminal justice system. We would like the public to cooperate with the police. We enforce the law. That's our job. That is what we do. So we would very much like if the public cooperates with us and don't give us too much of a hard time. Yes, you have your rights, exercise your rights, but do it within the confines of the law.
So before I want to leave the public with some food for thought, right? The prosecution department is vital for upholding justice and maintaining social order. Prosecutors must balance firmness and legal integrity and public interest. Continuous improvement and reform help strengthen the justice system, and they ensure the justice. The departments looking for the continuous support from individuals out there. Without your support, without your assistance, we cannot achieve our objective. And I don't want the public to see us as an enemy, but as a friend, as a brother, as a sister. We are working to achieve one common goal, and that is the safety of our citizens within Grenada, Carriacou, and Petit Martinique.
I want to take this opportunity to thank both of you gentlemen this morning, Corporal Charles and Constable Williams, for joining us here on the program, The Conversation with the RGPF, right here on Real 91.9 and 91.5 FM, right here, Main Street Sutters. And of course, we look forward to having you some other time on the program. And to those of you who are listening of our social media platform, we thank you for logging on to us. And of course, we are going to be back in studios next Wednesday, God's will, to have another program, The Conversation. And I did enjoy the company with you this morning. So at least share some information. If you see something, you hear something, you know something, feel free to report that matter to the nearest police station, or find someone that you can trust within the RGPF to relay the information, because we want to be able to keep our country safe and to, of course, reduce the whole issue of the fear of crime. And so I want to encourage each and every one of you as you go through this day to look out for someone. You know, I prefer that you would give more than you take, you know, and lend a helping hand to someone, you know, and of course, help someone reach to the top of the ladder. Don't go there by yourself. You know, it's always important to carry someone with you, you know, inspire someone, be a motivation for someone, you know, as you go through this day. So thank you, gentlemen, for being here on the program this morning, and do have a wonderful day. God bless you.
Welcome.
Yes, sir.
I am a prayer